My name is Alexandra Wells. I'm a research assistant at the Jean Monnet Network on Transatlantic Trade Politics. This is part of a series of interviews for the network called the Transatlantic Trade Videos. We're here today with Kyla Tienhaara, who is a Canada Research Chair in Economy and Environment and an Assistant Professor in Environmental Studies and Global Development Studies at Queen's University in Kingston, Ontario. Welcome, Professor Tienhaara, and thank you for taking the time to speak with us today.
Thanks very much for the invitation. It's great to be here.
So in our interview today, we want to focus on investor-state dispute settlement, or ISDS, in trade agreements. To begin, can you explain what ISDS provisions in trade agreements are about?
Yeah, so basically ISDS is a process that allows a foreign investor to take claims for monetary compensation against a state directly to an international panel. The panel is made up of 3 arbitrators. One is chosen by the state, one is chosen by the investor, and then they mutually agree upon the third. And basically, it varies depending on the treaty. Sometimes this process has some degree of transparency. Sometimes it's completely behind closed doors. But the essence of it is that it's a direct and legal process, and it's outside of the domestic courts of the host state.
So you have a critical opinion of investor-state dispute settlement. In your opinion, what is the impact of ISDS on international trade and investment?
There's 2 separate parts to the critique, I guess. My focus is primarily on the impact that these disputes and these claims made by investors can have on the power of the state to regulate in the public interest, and particularly I focus on issues around environment and increasingly around climate change. But the other aspect is what do these treaties and what does access to ISDS do in terms of facilitating investment, because that was their original purpose. And the evidence there, although this is not the area that I conduct research in, I've read a lot of the research, the evidence there is that they actually don't have any benefits, so they don't have an influence on flows of foreign investment. So the countries that are signing up to these agreements are accepting a lot of risk associated with being able to be sued by investors, but they're not reaping any benefits in terms of increased foreign investment coming into their country.
And how have these concerns about investor-state dispute settlement contributed to the politicization of trade agreements, particularly in a transatlantic context?
Well, they have been the ISDS provisions are extremely controversial. Particularly, it's been taken up by a number of civil society organizations in North America and increasingly in Europe, and they've managed to explain to the public what these are very sort of technical legal kind of issues that can be really hard to understand as a layperson, but they've done a good job of sort of translating to the public what these provisions in these treaties mean and what ISDS is about, which has been particularly important because it is in many cases quite a confidential process, and there's not much public information released. So the work that these groups have done has really sort of broken open the black box of what's going on inside these arbitrations. It's also just the fact that the more and more cases we have, the more people realize the potential implications of the provisions that have been accepted, especially when you get disputes brought over important public policy measures. So, for example, I lived in Australia for 10 years, and this is outside transatlantic discussions, but there a really controversial case was that Philip Morris brought a case against the Australian government for bringing in a policy to have plain packaging of cigarettes. The effort was to try to reduce smoking and prevent bad health outcomes from smoking, and the company sued the government, saying that this was a breach of an investment treaty. Didn't actually win the case in the end, but it took many years. It cost a great deal of money, and it was rather on a technicality that it lost the case. So big cases like that really get people upset and worked up. So in the transatlantic context, there's been 2 big treaties. The TTIP was a proposal between the U.S. and Europe, the Transatlantic Trade and Investment Partnership, I believe. It's so many acronyms. And ISDS was definitely one of the hot button issues. I mean, the treaty got derailed for many reasons, and I wouldn't say that ISDS was the number one reason, but it was certainly part of it. There was a big campaign to have people sign a petition against ISDS. I believe we got over 100,000 signatures, which is quite impressive. And as a result, Europe has really sort of moved towards trying to reform the ISDS system into a more established court. And it addresses some of the problems with ISDS, but I don't think it addresses all of them. But that is the system that was adopted in the case of CETA, which is the Canada-EU arrangements, which is still being decided upon by a number of governments in terms of specifically ISDS. So about a month and a half ago, I was speaking to a Senate committee in Ireland, which is still thinking through the issues about ISDS and whether they should provisionally apply the terms on investment. So it continues to be a concern particularly for a lot of European countries. Canada has taken sort of a mixed approach in the reformed NAFTA agreement, which is variably called the USMCA or the CUSMA, depending on which country you're in. There is no ISDS arrangement between the US and Canada. There still are legacy disputes under the old NAFTA, but it seems Canada recognized that there was a great risk in terms of US investors suing the country. At the same time, the government still adopts bilateral investment treaties, particularly with countries in the global south, where there's no risk to Canada, but a great deal of risk to those countries, particularly from Canadian mining investors. So, I would say it's definitely become one of the big issues, along with things like intellectual property rights, that also cause a great deal of concern.
Sure. And then in the CETA agreement between the EU and Canada, the investor state dispute settlement system was substantially revised in response to public criticism. Does the revised system address your concerns about ISDS?
No, to put it short. So basically the differences is that the ISDS is a very ad hoc system. So you have basically just any sort of private lawyer, former professors or current professors, judges, etc. They can be put in the position of deciding on a case. And one of the most egregious aspects of the system is that you can actually act as a lawyer for an investor or a state in one case, and then act as an arbitrator in another case, which introduces huge problems in terms of the potential for you to make a decision as an arbitrator that will help your clients in another case. Even though there's no formal system of precedent, there is still this pattern of arbitrators relying on the awards in other cases. So that type of issue just sort of concerns about bias and conflicts of interest is what the EU has tried to address in this more formalized system, where the arbitrators will be sort of on a standing roster. They won't be allowed to act in another role in the system. They have to sort of only be arbitrators. And there's also been so that's one the major reform in terms of the system. There's also been a whole bunch of reforms in terms of the substantive provisions to try to tighten up the language, which has been arguably interpreted by arbitrators and lawyers in ways that the states that drafted these treaties in the first place did not intend. I also don't think those reforms have gone far enough. Fundamentally, at the end of the day, it's a completely one-sided system. So investors can bring disputes against states, but states cannot bring disputes against investors. Citizens that have been negatively affected by an investment can't bring a dispute in the system against the investors. So it's completely one-sided. There's no obligations on investors to act responsibly, to comply with other norms of international law and human rights and environmental protection and so forth. So it's this completely skewed system. And as I've already noted, it doesn't actually provide any benefits to the public. So I don't understand why we should invest in this new sort of slightly better system, the ISDS, when we could just get rid of it entirely because it's not performing any important role.
Sure. And then in future, how do you think climate change and climate action needs to be addressed in international trade policy? Is there a way to effectively ensure through policy that companies are not using ISDS to directly challenge climate action?
Yeah, so this is a sort of a difficult question at the moment because there's a lot of focus on by NGOs and academics like myself on the fact that fossil fuel investors are starting to bring claims against governments when they take action to address climate change. So just a couple examples quickly. There are two companies in the Netherlands that are challenging the government over the phase out of coal power. There is the Keystone XL pipeline dispute, which basically is a Canadian company challenging Joe Biden's cancellation of very controversial tar sands pipeline project. In Canada, there's a challenge against, again, a coal phase out, but this time it's from a coal mining company, Westmoreland Coal. There's also a case in Italy challenging a ban on offshore oil and gas extraction. So, I mean, this is sort of just, I think, sort of the tip of the iceberg, because governments haven't up until now really been taking the kind of direct action against fossil fuel companies that I think is actually necessary to address climate change. There's increasing studies and evidence that says basically we have to keep a very large proportion of known fossil fuel reserves in the ground. The International Energy Agency has said that no new oil, gas, or coal projects are sort of consistent with a 1.5 degree scenario for the energy transition. So there's just huge potential if governments actually act for these companies that have made investments in continuing to extract fossil fuels seemingly forever, despite a lot of their net zero claims. Most of them are relying on technologies like carbon capture and storage coming online that are just really unlikely to be economically viable, if even technically viable. So there's just huge potential for a lot of asset value to be lost in the transition, and when that happens, there's just going to be claims for compensation. And my concern, and the concern of others, is that these treaties are going to be used to push the costs of the transition entirely onto the public sphere. And it's important to note that these companies can ask not just for the money that they've spent to date in trying to develop their projects, but also for these speculative lost future profits. So what they imagine that they would have been able to make had there not been any government action, had there not been climate change, which is, I think, quite frankly, ridiculous. So there are a number of things that can be done to try to prevent this from happening. But basically, I think at the end of the day, what we need to do is get rid of the investment treaties. There's movement in Europe towards getting rid of the Energy Charter Treaty, which is specifically an investment treaty that's specifically focused on the energy sector. There are a number of European countries that have expressed the fact that they believe that it is inconsistent with the Paris Agreement. So there's a reform process going on at the moment, but if that process fails, as it seems likely to, then there could be an initiative by a number of European countries to sort of mutually cancel their participation in that agreement. And something similar could happen for the huge number of bilateral investment treaties that exist. There's over 2,600 treaties that we're talking about here. So it's not the case of just these big ones that we know about, like CETA and TTIP. There's all these bilaterals, but there could be a process where states just sort of agree to mutually cancel them. It would be difficult to do, but I think that that's the best way forward. Another option would be to come up with some kind of statement or position that fossil fuel companies should be excluded from being able to use these treaties. And there have been some suggestions that there are principles in international law in terms of the necessity defense, because this is an emergency. The climate emergency is very much an emergency situation, and that would necessitate canceling basically the permission that has been granted to fossil fuel investors to use these treaties. I think that might be a good option. The problem is that the system is used by a lot of other investors for egregious purposes, and it would be better to have a holistic approach where we got rid of the treaties entirely.
Sure. And this brings us to our final question. So in your research, you've also examined the importance of public action. Where do you see the role of public action in the international trade policy arena?
So yeah, it's one of these difficult things because it's hard to convey a clear message to the public about what these treaties are, how they operate, and why they're problematic. But once people understand what's going on, they usually are very upset about it because it just does seem like a very egregious thing that all of these treaties have been signed with very little public knowledge, and that it gives these corporations such great power. I do think that public pressure, though, can be incredibly important. I think that's demonstrated in Europe first with that large number of people signing that petition against ISDS, and sort of unfortunately that only resulted in modest changes to the system, but still it demonstrates the power of public pressure. I think that the ECT example as well shows that. I think especially if we can get the climate movement to really recognize what a threat this is to climate change, action on climate change, then that could be very helpful, because the number of people that sort of work on trade and investment in the activist space is quite limited, whereas the climate movement, I think, has a lot more momentum and strength behind it at the moment. But obviously the climate movement also has many aspects of the transition to address. So this isn't always their priority. But I think that especially when you see cases like Keystone XL, which that the cancellation of that project was a result of the power of social movements. So I would hope that those social movements would also look at the investor-state dispute being brought by the company as a big threat to future wins, and would see that that's something that they need to address.
That ends our interview today. And again, thank you, Professor Tienhaara, for joining us.
That was great. It was nice to chat with you.